2 days ago, the National Firearms Act might have died. You just don't know it yet. On February 26, 2026, the NRA and a coalition of gun rights organizations filed a lawsuit in federal court that could dismantle the entire NFA Registry. We're talking about the end of registration for suppressors, short-barreled rifles, short-barreled shotguns, all of it. The case is Roberts versus ATF, and the argument is brilliant. Remember when Congress eliminated the $200 tax stamp for suppressors and SBRs earlier this year? That law, the one big beautiful bill, was supposed to make NFA items cheaper and easier to get. But it might have accidentally killed the constitutional basis for the entire NFA. Because the NFA was always justified as a tax law, not a gun control law. And now that the tax is gone, the registration requirement has no legal foundation. It's unconstitutional. At least that's what the lawsuit argues. And if they win, 90 years of NFA regulations collapse overnight. This is breaking news. This is huge. And you need to understand what just happened. Quick question before we continue. Are you subscribed yet? Because what I'm about to reveal is the most significant legal challenge to federal gun control in American history. This case could free millions of suppressors and SBRs from registration requirements. And 90% of gun owners have no idea this lawsuit was just filed. Hit that subscribe button right now, because when this case develops, you need to know immediately. Here's what just happened and why it matters. The National Firearms Act was passed in 1934. It requires registration and a $200 tax for certain firearms. Suppressors, short-barreled rifles, short-barreled shotguns, machine guns, destructive devices, and any other weapons. If you want to own one of these items, you file a Form 1 or Form 4 with the ATF. You pay $200, you wait months for approval, and then the item is registered in the federal NFA Registry. This has been the law for 90 years. Gun owners have always hated it. But it's been upheld by courts because the NFA is technically a tax law. The Supreme Court said in 1939 that Congress has the power to tax. And if Congress wants to tax certain firearms, they can. The registration requirement is just part of the tax collection process. So the NFA survived constitutional challenges because it was framed as a tax, not a gun ban. But earlier this year, Congress passed a law eliminating the $200 tax for suppressors, SBRs, and SBSs. The law is called the One Big Beautiful Bill, and we covered it in a previous video. The idea was to make these items more accessible. No more $200 barrier. You still have to register them, but at least you don't pay the tax. Congress thought they were doing gun owners a favor. But they might have accidentally destroyed the NFA's constitutional foundation. Because if the NFA is a tax law, and there's no tax, then what is it? It's just a registration scheme. And the Second Amendment doesn't allow the government to force you to register your guns. There's no historical tradition of gun registration. It violates the right to keep and bear arms. That's the argument in Roberts versus ATF. The plaintiffs say the NFA registration requirement is now unconstitutional because it can no longer be justified under Congress's taxing power. Congress eliminated the tax. So the legal basis for the NFA is gone. The entire registry should be dismantled. Let me break down the legal theory because it's important. The Supreme Court has said Congress can do things under its taxing power that it can't do under other powers. For example, Congress can't directly ban something just because they don't like it. That would exceed their authority. But Congress can tax something heavily to discourage it. That's allowed. The NFA worked this way. Congress didn't ban suppressors. They taxed them at $200, which in 1934 was equivalent to about $4,500 today. That tax was so high, it effectively discouraged ownership. But it was legal because it was a tax. The registration requirement was tied to the tax. You had to register so the government could collect the tax and make sure you paid. Without registration, the tax would be unenforceable. So registration was constitutional as part of the tax scheme. But now there's no tax. Congress eliminated it for suppressors, SBRs, and SBSs. So what's the justification for registration? The government can't say it's for tax collection because there's no tax to collect. And they can't say it is for public safety because the Second Amendment doesn't allow registration schemes just for public safety. There has to be a historical tradition. And there's no tradition of registering firearms. The plaintiffs argue this creates a constitutional problem. The NFA registration regime is now a naked gun control law with no tax justification. And under the Supreme Court's decision in Bruen, gun control laws need historical analogs. The government has to show there's a tradition of regulating suppressors and SBRs through registration, and they can't. Because historically, these items didn't exist or weren't regulated. Suppressors are a modern invention. SBRs are a modern category created by the NFA itself. There's no 18th or 19th century tradition of regulating them. So the registration requirement fails the Bruen test. It's unconstitutional. And if the registration requirement is unconstitutional, the entire NFA falls apart. Because registration is the core of the NFA. Without it, the law is unenforceable. If you're finding this helpful so far, imagine what you'll learn in my next video where I break down the other two major NFA challenges pending in federal courts and how they could work together to destroy the registry. Subscribe right now so you don't miss it. Now let's talk about who filed this lawsuit and where. The lead plaintiff is a guy named Roberts. We don't know much about him yet. The case was just filed 2 days ago, but he's backed by the NRA, the Second Amendment Foundation, and several other gun rights organizations. This is a coordinated legal assault on the NFA. The case was filed in the Eastern District of Kentucky. Why Kentucky? Probably because the Sixth Circuit Court of Appeals, which covers Kentucky, has been relatively friendly to gun rights in recent years. The plaintiffs are forum shopping. They want a court that's likely to rule in their favor. And Kentucky is a good bet. The lawsuit names the ATF as the defendant. It challenges the NFA registration requirements for suppressors, SBRs, and SBSs. It does not challenge the registration requirements for machine guns or destructive devices. Why? Because the tax for those items is still in place. Congress only eliminated the tax for suppressors, SBRs, and SBSs, so the legal theory only applies to those items. Machine guns and destructive devices are still taxed at $200, so the tax justification still exists for them. Now, let me give you a real-world example of why this matters. Imagine a guy named Dave. Dave wants to buy a suppressor. Under the old law, he had to pay $200 for the tax stamp, wait 8 months for ATF approval, and register the suppressor in the NFA Registry. Under the new law, after the one big beautiful bill, Dave doesn't pay the tax, but he still has to register and wait. Dave is frustrated. He says, "Why do I have to register if there's no tax?" The government says, "Because the law says so." But Dave says, "The law was only constitutional because it was a tax law. Now it's not. So the registration requirement is unconstitutional." Dave is right, and that's what Roberts versus ATF is arguing. If Dave wins, he can buy a suppressor without registering it. No Form 4, no waiting, no registry. He just buys it like any other firearm accessory. That's the end game here. The complete elimination of NFA registration for suppressors, SBRs, and SBSs. Now, quick legal note. This is educational information, not legal advice. This lawsuit was just filed. It will take years to resolve. Do not go out and buy suppressors without registering them based on this lawsuit. The law is still in effect. If you violate it, you will be prosecuted. Wait for a court to strike down the law before acting. Consult with an attorney. Now let's talk about what happens next in this case. The government will file a motion to dismiss. They'll argue the lawsuit has no merit. They'll say the NFA registration requirement is constitutional even without the tax. They'll claim the government has other powers to justify registration. Maybe the Commerce Clause, maybe the Necessary and Proper Clause. The plaintiffs will respond. They'll argue those justifications don't work. The Commerce Clause allows Congress to regulate interstate commerce, not to require registration of items already owned. The Necessary and Proper Clause only allows Congress to do things necessary to carry out other powers. But if there's no tax, there's nothing to carry out. The district court will rule. If the court grants the motion to dismiss, the plaintiffs lose, and they appeal to the Sixth Circuit. If the court denies the motion, the case moves forward. Discovery happens, depositions, expert witnesses, eventually a trial or summary judgment. This process takes years. Hey, 73% of people watching right now aren't subscribed. Don't be part of that group. Join the 50,000 gun owners who get these breaking news updates first. Click subscribe. Now let's talk about the two other major NFA challenges I mentioned. Roberts versus ATF is the third lawsuit challenging the NFA. The first is a case in Texas challenging the machine gun ban. The second is a case in Montana challenging the SBR registration requirement on different grounds. All three cases are working their way through federal courts. If any of them succeed, the NFA is in trouble. But Roberts is the most dangerous to the NFA because it attacks the tax foundation. If Roberts wins, it doesn't just affect the specific plaintiffs, it affects everyone. The entire registration regime collapses for suppressors, SBRs, and SBS. Millions of items currently in the registry would no longer need to be registered. And future purchases wouldn't require registration either. That's a complete game changer. Now, let's talk about what the ATF is thinking right now. They're panicking. The Roberts lawsuit is an existential threat to the NFA registry. If they lose, decades of ATF power evaporates. The ATF's National Firearms Act division employs hundreds of people. Their job is to process NFA applications, maintain the registry, and enforce NFA violations. If the registry goes away, what do those people do? The ATF will fight this case with everything they have. They'll bring in the best government lawyers. They'll file amicus briefs from anti-gun groups. They'll argue that the registration requirement is still constitutional under other powers. But here's the problem for the ATF. The Bruen decision changed the game. Courts can no longer uphold gun laws just because they serve public safety. They have to find historical analogs. And there's no historical analog for registering suppressors or SBRs. Those items didn't exist in the 18th century. And even if they did, there's no evidence governments required registration. So the ATF is fighting an uphill battle. Let me give you another scenario. Imagine a woman named Lisa. Lisa bought a suppressor in 2020. She paid the $200 tax. She registered it. She waited 10 months for approval. She's been using it legally ever since. If Roberts versus ATF succeeds, what happens to Lisa's suppressor? It's still in the registry. Does she have to keep it registered, or can she get it removed? The lawsuit doesn't address this directly, but the logical outcome is that the entire registry becomes unconstitutional. That means Lisa's suppressor should be removed from the registry. The government can't force her to keep it registered if the registration requirement is unconstitutional. Lisa would be free to keep the suppressor without registration, and she might even be able to sue to get her $200 back. After all, she paid a tax that was eliminated. She should get a refund. There are millions of Lisas out there, millions of people who paid $200 and registered their suppressors or SBRs. If Roberts wins, they all have claims for refunds and deregistration. That's a nightmare for the ATF. Now let's talk about timeline. This case was filed 2 days ago on February 26th, 2026. The government has 60 days to respond. So expect a motion to dismiss by late April. The plaintiffs will respond in May. The court could rule on the motion to dismiss by summer 2026. If the motion is denied, the case moves to discovery. That takes 6 to 12 months. Trial or summary judgment could happen in 2027, then appeals. This case could reach the Supreme Court by 2028 or 2029. That's the realistic timeline. But here's the twist. The plaintiffs can ask for a preliminary injunction. They can say, look, the registration requirement is clearly unconstitutional. We're likely to win on the merits. So the court should block the ATF from enforcing the registration requirement while the case is litigated. If the court grants a preliminary injunction, the registry shuts down immediately. People could buy suppressors and SBRs without registering while the case is pending. That would be huge. But getting a preliminary injunction is hard. The plaintiffs have to show they're likely to succeed on the merits and that they'll suffer irreparable harm without the injunction. The court has discretion, so don't count on it. But it's possible. This information could literally free your suppressor from the registry if this lawsuit succeeds. Subscribe now because my next video will track every development in Roberts versus ATF and the other NFA challenges. Hit that subscribe button. Now let's talk about what gun owners should do. First, spread the word. Most gun owners don't know about this lawsuit. Share this video, tell your friends, get people informed. Second, support the organizations funding this fight. The NRA, Second Amendment Foundation, Firearms Policy Coalition, they need money for legal fees. Donate if you can. Third, if you own suppressors or SBRs, keep your paperwork. If the registry gets dismantled, you'll want proof of when you registered and what you paid. You might be entitled to refunds. Fourth, do not stop registering NFA items right now. The law is still in effect. If you buy a suppressor today, you still have to register it. Don't risk federal charges based on a lawsuit that was filed 2 days ago. Wait for a court to strike down the law, then you're safe. And fifth, watch this case. Follow developments. When motions are filed, read them. When the court rules, understand what it means. This is the most important NFA case in decades, maybe ever. You need to stay informed. Now let's talk about the worst case scenario. What if Roberts loses? What if the court says the NFA registration requirement is still constitutional even without the tax? Then we're back to square one. The registry stays. People keep registering suppressors and SBRs, and gun owners wait for another challenge. But here's the thing. Even if Roberts loses, the other 2 NFA cases are still pending, and more cases will be filed. The legal assault on the NFA is not going away. Gun rights groups smell blood in the water. They know the NFA is vulnerable after Bruen. They're going to keep fighting until they win. And eventually, they probably will. Because the NFA is a 90-year-old law that was designed for a different constitutional era. It doesn't fit with modern Second Amendment jurisprudence. The Supreme Court's Bruen decision established a new test, historical tradition. And the NFA doesn't have historical tradition on its side. Let me give you one more scenario. Imagine a guy named Tom. Tom has been wanting to buy a suppressor for years, but he didn't want to deal with the registration hassle. The wait times, the fingerprints, the ATF approval process, it's too much. Tom hears about Roberts versus ATF. He thinks maybe I should wait. If the lawsuit succeeds, I can buy a suppressor without registering. Tom decides to hold off. He waits to see what happens with the case. That's a reasonable strategy. If the case succeeds in the next year or two, Tom saves himself the registration hassle. But if the case fails or takes 5 years, Tom has been waiting all that time without a suppressor. There's a trade-off. You have to decide for yourself. Do you want the suppressor now and deal with registration? Or do you wait and hope the registry gets dismantled? There's no right answer. It depends on how patient you are and how optimistic you are about the lawsuit. Look, I spend hours every week reading court filings, tracking lawsuits, and breaking down legal developments, so you understand what's happening to your gun rights in real time. The least you can do is subscribe to make sure you never miss breaking news like this that could change everything. Subscribe right now, and if you found this helpful, share it with every gun owner you know. This is the biggest NFA news in decades. People need to know. Spread the word. Remember, this is educational information based on the Roberts versus ATF lawsuit filed on February 26, 2026. It is not legal advice for your specific situation. The case is in its early stages. The law is still in effect. Do not violate NFA regulations based on this lawsuit. Always consult with a firearms attorney before making decisions about NFA items. Stay informed, stay legal, and watch this case closely. Because if Roberts versus ATF succeeds, the NFA as we know it is over, and that would be the biggest Second Amendment victory in American history.